So friends, there's some breaking news involving two federal prosecutors in my former office, the DC U.S. Attorney's Office. And what we're learning is these two federal prosecutors put some truthful, accurate, necessary information in a court filing in what's called a sentencing memorandum for a defendant who is about to be sentenced by a judge after being convicted at trial. And because that sentencing memorandum said that there had been an attack on the U.S. Capitol on January 6th and also provided some context for the crimes that this defendant had been convicted of, which were not January 6th crimes, but that was relevant to the sentencing of this particular defendant. That memo also referenced Donald Trump one time. And within hours of that court filing, these two federal prosecutors doing the hard, honest, ethical work of the American people had their government phones seized, were locked out of their government computers, and were ejected from the United States Attorney's Office, walked out of the building for telling the truth to a federal judge in a court filing. So I jumped on for another episode of what we're calling the prosecutor's verdict with my friend, former colleague, and former career prosecutor himself, Kevin Flynn, to talk about this searing injustice. So let's talk about it, because justice matters.
Hello, everybody. I see everybody signing on. I know you all saw me just a few minutes ago with my friend Dean Obidala, but this is something that Kevin and I wanted to jump on and talk about as part of our sort of occasional series that we call the Prosecutor's Verdict. I have a feeling you may be seeing more of both of us talking about the abuses of the rule of law. I just saw that one of the
congressional candidates out in Chicago, somebody I've interviewed on my YouTube channel, Kat Abu-Ghazaleh,
was just indicted for protesting peacefully outside an ICE facility. And let me just tell everybody, when they see these stories, and it angers us and it fills us with anxiety and with dread, rest assured that every time another one of these cases, these vindictive prosecutions, these baseless evidence-free prosecutions result in a dismissal or a not guilty finding by a jury, that weakens Donald Trump. And there's more of that coming. So don't despair at what seems to be horrific, bad news, but hold tight, because we are going to win this battle. We have no alternative. We have to win this battle. So as people sign on, let me do a more formal introduction. All right, welcome everybody back to another episode, I think we can call it, of the Prosecutor's Verdict. You're becoming familiar with my friend and former colleague, Kevin Flynn. Kevin and I were both federal prosecutors for our entire careers in the same office, the DC U.S. Attorney's Office, which is obviously part of the Department of Justice. I was a prosecutor for 30 years. Kevin was a prosecutor for 35 years. So we like to jump on and talk about some of these, outrages that we're seeing that pertain to the rule of law or the conduct of the Department of Justice. And we call it the prosecutor's verdict because at the end, we kind of render our verdict or our opinion on what it is we're seeing being done by the Pam Bondi, Todd Blanche, Donald Trump Department of Justice. And there was a story that broke this morning that we both really wanted to jump on. So first of all, Kevin, welcome back, and being willing to do this over and over again, talking about the abuses of the rule of law that we're seeing.
I wish we didn't have so much material to talk about. Somehow, I don't think we would have had that much to deal with back about maybe a year ago or 2 years ago or 3 years ago, or maybe 35 years ago, for example.
I wish we could put ourselves out of business. not
Yeah.
having to talk about the abuses of the rule of law. And let me just add, when Kevin and I were homicide prosecutors in DC, unfortunately, business was always way too good. We had way too many murders in DC. One is too many, but we had more than our share. And we would always talk about how we wish we could put ourselves out of business. We wish they didn't need us investigating, indicting, and prosecuting murder cases in our nation's capital or anywhere else. But unfortunately, crime remains consistent really throughout all administrations. But so let's talk about what we just saw in the reporting today. It involves a former January 6th defendant by the name of Taylor Franklin Taranto, who was convicted for crimes he committed at the Capitol on January 6th. He was pardoned, but he didn't stop committing crimes. He continued to commit crimes, including the ones we're going to talk about today. And he was scheduled to be sentenced for these new crimes that he committed, not the January 6th crimes for which he'd been pardoned. And two of our, I guess, loosely speaking, former colleagues, these are federal prosecutors who work at the DC U.S. Attorney's Office. These two federal prosecutors filed a sentencing memo in defendant Taylor Franklin Taranto's case. And within hours of filing this sentencing memo, which we do routinely in every criminal case as the case approaches the sentencing phase, they got their cell phones, their government phones taken away. They were locked out of their computers. They were marched out of the DC U.S. Attorney's Office. The reporting isn't that they were fired, but the whole thing sure looks a lot like they are going to be wrongfully terminated because they filed the sentencing memo in the case. So now that I've kind of set it up, Kevin, let me throw it over to you to kind of have you explain more about what we're seeing in the sentencing memo and in the reporting.
Sure. It appears that the offending now, of course, there's no comment from the department about this, but it appears from the content of the sentencing memorandum that the two offending paragraphs or parts related to January 6th, and specifically an allegation, but the prosecutor's representation that the defendant had been part of what the memorandum referred to as a mob of rioters, which is what he was part of, which is what that group was. It was a mob, and it committed violent acts in an insurrection. That is a fact of history, which the current administration wants to have whitewashed, but it remains a fact, and it is a relevant fact in the sentencing of this particular defendant, beyond question. There was also a reference in the sentencing memorandum to the fact that the defendant was present in the area where he has been found guilty of committing criminal offenses because of the fact that former President Trump had published the home address or publicized the home address of former President Barack Obama, which prompted one of his violent followers, to go into that area. And so those references were enough for the Department of Justice to essentially fire two prosecutors who were involved in filing that sentencing memorandum. A memorandum, as you have observed here, which is filed. It may not be filed in every single, say, misdemeanor case, but it is certainly filed in every felony case as a matter of routine in our old office. And certainly, I think it's probably filed. Sentencing memoranda are probably filed around the country by U.S. attorneys' offices in federal court because their caseloads are not as heavy as our caseload. The caseloads that you and I maintained in D.C. Superior Court, and so it is a routine part of the procedure. It was filed in front of before a judge who had found this defendant guilty of criminal offenses in a bench trial, and it was entirely appropriate for it to be filed, and it was entirely appropriate for it to contain all of the relevant facts that pertain to this defendant's past conduct, his criminal conduct, and what sentence he should receive from the court for his crimes of conviction.
And let's talk a little bit about what Taranto is alleged to have done, what he was convicted of, what the evidence showed. Part of what he did was he was live streaming. He was both posting and live streaming about how he was going to drive his van to Barack Obama's house. His van was basically, he alleged, a rolling explosive device with some kind of an automatic detonator in it. And then he was live streaming how he was driving through Barack Obama's neighborhood. And how did he know where Barack Obama lived? As Kevin said, because Donald Trump the day before had posted Barack Obama's home address. What kind of a signal do you think that is or sends to Donald Trump's most rabid and reckless, indeed criminal supporters? Well, this guy Taranto took that information, armed himself with multiple firearms, hundreds of rounds of ammunition in his van, and headed to and live streamed his trip into Barack Obama's neighborhood. So let me just read to flesh out some of the details that Kevin shared about the two passages in this sentencing memorandum that we think probably got these two attorneys retaliated against, if not fired. You know, Kevin and I, before we went live, were talking about how, you know, usually you treat spies against America this way. You lock them out of their phone, you lock them out of their government computer, you frog march them out of their federal building. You ordinarily put them under arrest immediately. And this is what they're doing to prosecutors who have the nerve to put truthful, accurate information into a sentencing memo that's provided to a federal judge. So here are the two passages we suspect were the offending passages. One says, on January 6, 2021, thousands of people compromising a mob of rioters attacked the U.S. Capitol while a joint session of Congress met to certify the results of the 2020 presidential election. And Taranto was accused of participating in the riot in Washington, D.C. by entering the U.S. Capitol building. And after the riot, Taranto returned to his home state in Washington, where he promoted conspiracy theories about the events of January 6th, 2021. And importantly, he was criminally convicted for the crimes he committed at the Capitol that day and was pardoned. But friends, rest assured, that's information that the judge who is about to sentence Taranto for his new crimes absolutely needs to know and take into account as he is fashioning an appropriate sentence. Here's the second passage. The next, on January 29, 2023, then former President Donald Trump published on a social media platform the purported address of former President Barack Obama. I remember when that happened. At the time, I did videos about how reckless and dangerous, and dead wrong it was for anybody to publish the home address of a former president of the United States. But that's what Donald Trump did. This defendant, Taranto, reposted the address on the same platform and thereafter started live streaming from his van on his YouTube channel. Taranto broadcast footage of himself as he drove through Barack Obama's neighborhood in D.C., claiming he was searching for tunnels he believed would provide him access to the private residences of certain high-profile individuals, including President Obama. He parked his van, walked away from it, and approached a restricted area protected by the United States Secret Service. He, the defendant, walked through the nearby woods and stated, "Gotta get the shot. Stop at nothing to get the shot." After noticing the presence of Secret Service, he said, "If I were them, I'd be watching this, watching my every move. I control the block." And it goes on. So the two things he said, as Kevin points out, that a mob attacked the Capitol on January 6th. He was one of the members of the mob who committed crimes that day, and that he went to Barack Obama's neighborhood after Donald Trump had posted Barack Obama's address. And for that, it appears, based on the reporting, they were, frog marched out of the U.S. Attorney's Office, the Department of Justice, and locked out of their government phones and their computers. Again, let me throw it back to you. And what is it that jumps out at you about all of that, Kevin?
Well, well, let me just start out by saying that you made the observation that these facts, the past conduct of this defendant, are relevant to the sentencing decision that a judge is going to make. And that does not just apply here. We're not just singling out this defendant for his January 6th crimes, for which he was pardoned, and then saying that in this particular case alone, the sentencing judge was entitled to know about the defendant's past conduct. That it is something that judges are entitled to know in every single case in which they are going to sentence a criminal defendant. A lot of your viewers, a lot of our viewers here might not be familiar with the process, but once a conviction has been entered onto the record, either by way of a guilty plea or a guilty verdict, then the case does generally, in almost all cases, does not go directly to sentencing. There is an inquiry that is conducted by an arm of the government, generally a probation office. Certainly in the federal system, the probation office conducts an inquiry, an investigation into the defendant's background, his criminal history, his marital status, his drug history, various things that both good and bad about this defendant that can be taken into account by the judge. And there are guidelines that are set in place by federal statute called the Federal Sentencing Guidelines. And these guidelines explicitly set forth the factors with which a judge should take into account in imposing a fair and just sentence on a defendant. And a good part of those considerations come down to the defendant's past history. So it is not by any means unfair play for the government to cite, in this particular case, to the defendant's past crimes. In fact, it is essential to the sentencing process and the process that the judge is presiding over. But at the end of the day, a process that needs to afford that judge, him or her, with whatever information that he or she needs to be able to fashion the appropriate sentence. So this is a time-honored procedure, and it is one that is observed by both defense counsel and the government. And so once that investigation has been undertaken, a report is issued by the arm of the court to the judge, and both sides then have the opportunity to weigh in with a memorandum in aid of sentencing. And that's the government putting forth its position as to why the defendant should receive a particular sentence, and the defense countering with their own memorandum, which sets forth the facts and the circumstances that they believe most benefit their client in allowing the judge to fashion a more lenient sentence generally. This is the process. This is the way it works. I don't have before me the defense sentencing memorandum, but I would imagine that it followed the same format. And this particular memorandum that you've read from it's a model of the form. You and I have read hundreds of these. We have written hundreds of these. This is in the way that it's styled, in the way that it's written, in the professional approach that it takes. It is at the top of the form, and so this process was legitimately and accurately and gone about in good faith by these prosecutors. And I'll just say one more thing about the way that they've been treated. It's a way that hundreds, if not thousands, of other federal employees have been treated, being fired for being allegedly on the wrong political side of the administration, or for having views that people in the administration disagree with, or just simply having been appointed by another administration. And there is a way in which civil service rules should be applied. People have process. They're given notice. You and I, over the years, both of us were supervisors, and both of us observed over the years to each other and to others about how hard it was to fire civil servants. But we recognized that. We appreciated it. All right. People are entitled to process. And I'm just going to point out these two particular prosecutors. I don't know them, but they have lives. They came into work today, having filed a document, righteously filed a document in pursuit of justice. And now they're sitting at home, not knowing if they're going to see another paycheck even after the shutdown. The cruelty is the point. Intimidation is the point. The point of an action like this is to scare people. It's to induce fear. And I'll go one step further. The people who are responsible for acts like this, there's something twisted about them. And there is a ring of hell reserved for them. I'm not going to say it's the innermost ring, but it's not in the suburbs either.
Yeah, and it would almost be irresponsible for prosecutors not to put in a sentencing memo to a judge information like this about prior conduct of a defendant that goes to, for example, the rehabilitative potential of that defendant. He's a repeat offender, and my sense, Kevin, is that what probably angered the Trump flunkies the most, people like Pam Bondi and Todd Blanche, the Deputy Attorney General, the number two, and just loosely the way the hierarchy works when you get over to the DC U.S. Attorney's Office. You've got the Attorney General, the Deputy Attorney General, you've got the United States Attorney, who is the top prosecutor. God help us, it's Jeanine Pirro in DC at the moment. Over at the DC U.S. Attorney's Office, just blocks away from the main Department of Justice building. So, essentially, that's kind of the chain of command. So I would venture an informed guess that the people who were offended by this, ultimately it was dear leader Donald Trump, were some combination of U.S. Attorney for DC Jeanine Pirro, Todd Blanche, Pam Bondi. And, I would strongly suspect that the thing that offended them most is when they said, well, Donald Trump posted Barack Obama's address, and the next day, this defendant, who Donald Trump had pardoned previously for J6 crimes, used that information, reposted it, and made a beeline to Barack Obama's house, intending him harm. That's probably information that would displease dear leader because it highlights how dangerous he is and how recklessly some of his followers will respond to his every word and his every post. And I am always reminded of George Orwell's 1984, because it feels like maybe these two prosecutors failed to run this through the Ministry of Truth, so they could cleanse anything out of it that might offend dear leader. And because they kept that truthful information in there, they were, treated horrifically. And it looks like they'll probably be wrongfully terminated from the Department of Justice. So I am anxious to go ahead.
Just to clarify, on the timeline, I believe that, I believe that the sequence is January 6th, 2021 is when he commits his offenses. He is charged criminally at some point after that, and then in 2023, that's when the posting is made by then former President Trump, and this is presumably when this defendant was on release from his federal case. He's convicted in a bench trial earlier this year. But it was the bench trial followed the pardon. The conduct preceded the pardon, but it doesn't really matter. I'm just setting out the timeline.
And if I ever mangle a timeline, please jump in and correct me. So I am interested to see. I think this is Judge Carl Nichols. Let me double check.
It is.
Is that? Yeah. So Judge Carl Nichols, who is a pretty well-regarded judge, he is a Trump appointee who presided over some high-profile trials, including the Proud Boys trials. I'll be interested to see what happens when this case now makes its way into court for sentencing, and whether it will be a topic of discussion regarding whether these two prosecutors were, terminated or suspended for the representations they put in the sentencing memo.
The interesting thing here is that I'm not. There's only on the sentencing memorandum itself. There is Jeanine Pirro's name, and then there are the two line prosecutors underneath, Carlos Valdivia and Samuel White. I'm not familiar with them, but I don't believe that either one is a supervisor in the U.S. Attorney's Office. And I would imagine, now I don't know this for a fact, but I do know the way that office used to work. And I would think it's fair to say that in this respect and in this case, it would work in the same way. That supervisors would have been involved in, a supervisor would have been involved in reviewing this memorandum. I was surprised, and I shared my surprise with you, that this case even survived the changeover post pardon. I'm surprised that the department, that our old office, didn't, in fact, accede to the defendant's request to have the case dismissed, and didn't take the position that, in fact, it was covered by the January 6th pardon. Remember, one thing that makes this whole thing so ironic is that two prosecutors have been now disciplined, probably fired, over references to January 6th, when in fact it was this defendant who in his motion to dismiss this case, intertwined his conduct in 2023 with his conduct on January 6th, and said that they were so closely connected that he should be held to have been, his conduct in 2023 should be held to be included within the ambit of the pardon of his January 6th conduct. So the defendant raises January 6th, makes that a big part of his litigation strategy to try to get rid of this case, that motion presumably having been denied. And then after that, the government's prosecutors are disciplined for having referred to January 6th. The irony is rich. But I can't imagine that this sentencing memorandum, that these two prosecutors went rogue and just decided to file this without running it past the chain. And so somebody else's head is on the chopping block here. And I don't know whether this went all the way up to U.S. Attorney Pirro, and man, that is a tough title to wrap around with that name. But anyway,
yeah. And here's what I'll say, and this will be my last observation. U.S. Attorney Jeanine Pirro supervises these prosecutors and all prosecutors in the D.C. U.S. Attorney's office. And the fact that she is either hanging them out to dry or allowing others to direct that they be hung out to dry, to the extent I know anything about leadership or supervision, I probably learned it as an Army officer back in the 80s when I was prosecuting court-martial cases. The three most important rules of leadership are support your people, and support your people. And that Jeanine Pirro would not only not support her people, but would either punish them or let others punish them is like the ultimate sin of supervision and leadership. It doesn't mean you cover up your subordinates' misconduct. You don't. You hold them accountable if there's misconduct. But my gosh, if there's not misconduct, if you're doing your job the way we expect and demand you to do it, like filing this sentencing memorandum, which was important and necessary and apparently accurate in all respects, to allow one of your subordinates to be punished under those circumstances. I know, Kevin, you and I both had to stand up for our subordinates when times got tight and we needed to step in and make sure they were entirely supported. That is just kind of the ultimate sin and shortfall of a supervisor or of a leader. So if you had to render a verdict, because this is the prosecutor's verdict, and it's wide open, what is the most important takeaway from this really debacle, this searing injustice that it appears to be?
Well, I've already sentenced somebody to an inner ring of hell. So I think my sentence is I've put my sentence, but the horse before the cart, so to speak. But the verdict I would render is just improper, petty, small. I stack pejoratives on top of each other.
And it feels like vindictiveness is a recurring theme in the Donald Trump, Pam Bondi Department of Justice, whether it is vindictively indicting people like Letitia James and James Comey, or literally vindictively retaliating against your own people, the people you're there to support, by, I guess, being fearful of how dear leader might perceive something. Therefore, you're willing to sacrifice your own good, hardworking prosecutors who are literally doing the work on behalf of the American people, and just to make sure dear leader doesn't blow a gasket. I mean, it is such an abdication of the responsibility of a leader and a supervisor. And I guess I shouldn't be surprised, because I don't think anybody has alleged that Jeanine Pirro is any kind of a leader or a supervisor, but this surely drives home that point.
The tragedy, if I could just make one last point here, the tragedy is that this is going to limit the effectiveness of that office in prosecuting righteous cases and keeping the citizens of DC safe and investigating and prosecuting serious crimes of public corruption and financial fraud and all manner of other offenses, because it is going to this kind of conduct, this very public act of disciplining these prosecutors is going to drive people in that office out. It's going to make it harder for that office to recruit qualified, competent, non-ideological people. And as this process goes on, you're going to see an erosion in terms of the successes that are achieved by that office. And what's really, really important for people to understand is that it's commonly considered that the premier U.S. attorney's office in the country is in Manhattan, the Southern District of New York. In fact, its nickname is the Sovereign District of New York. But I have to say that I knew people who went from our office to SDNY. I knew people who came to our office from SDNY, and they would share with me that we had better trial lawyers because we had a higher volume of cases. We just took more cases to trial. I guarantee you that there is nobody who has the combination of jury trial experience in the Southern District of New York that you and I had. You could put 5 or 6 or 10 people together, and so this U.S. Attorney's Office, this D.C. U.S. Attorney's Office, is extremely important in the system, and it is being destroyed from within.
Yeah. And let me just add, it's not that we have more jury trials than the prosecutors in the Southern District of New York U.S. Attorney's Office or any of the other 92 U.S. Attorney's offices for any reason other than in D.C., as I know our friends on this live know, we're not only the federal prosecutors, we do all of the federal cases, but we also do all of the local D.C. cases. So that's how Kevin and I would, we had dozens and dozens and dozens of murder trials because we do like the work of the Manhattan District Attorney's Office, Alvin Bragg, and the Southern District of New York U.S. Attorney's Office all rolled into one. That's why I think it's the best place in the world to prosecute, because you have that really vibrant practice of federal cases and local cases. And boy, we do more trials perhaps than all other U.S. attorneys' offices combined. And it was an honor to work there for decades alongside Kevin. So thank you for jumping on with me, Kevin. I suspect we'll have something to talk about tomorrow and the next day and the next day. So we will continue to do these episodes of The Prosecutor's Verdict. And thank you, everybody, for jumping on. I will see you tonight at the community meeting at 8 p.m. because we've got a lot of legal terrain to cover tonight.
Great to talk to you, Glenn.
All right. See you, Kev.
See you now.